This is Barry Zalma on insurance. I am an attorney who is retired from the practice of law and now spend my time acting as an insurance claims consultant and expert witness, an author, and producer of these videos. Today, I'd like to talk about the statutory basis for the tort of bad faith, which began with the enactment of California Insurance Code Section 790.03. Today I'm just going to read it so you'll understand how everything came about. And this was before the rest of the country took up the tort of bad faith and provided a basis for the minimum standards required to properly adjust claims, at least in the state of California. It said, quote, "The following are hereby defined as unfair methods of competition and unfair and deceptive acts or practices in the business of insurance. A. Making, issuing, circulating, or causing to be made, issued, or circulated any estimate, illustration, circular, or statement misrepresenting the terms of any policy issued or to be issued, or the benefits or advantages promised thereby, or the dividends or share of the surplus to be received thereon, or making any false or misleading statements as to the dividends or share of surplus previously paid on similar policies. B. Making or disseminating or causing to be made or disseminated before the public in this state in any newspaper or other publication, or any advertising device, or by public outcry or proclamation, or in any other manner or means whatsoever, any statement containing any assertion, representation, or statement with respect to the business of insurance, or with respect to any person in the conduct of his or her insurance business which is untrue, deceptive, or misleading, and which if is known or which by the exercise of reasonable care should be known to be untrue, deceptive, or misleading." The statute's most important part dealing with bad faith then skips down to subpart H, which provides that it is a wrongful act of insurance to knowingly committing or performing with such frequency as to indicate a general business practice any of the following unfair claim settlement practices. 1. Misrepresenting to claimants pertinent facts or insurance policy provisions relating to any coverages at issue. 2. Failing to acknowledge and act reasonably promptly upon communications with respect to claims arising under insurance policies. 3. Failing to adopt and implement reasonable standards for the prompt investigation and processing of claims arising under insurance policies. 4. Failing to affirm or deny coverage of claims within a reasonable time after proof of loss requirements have been completed and submitted by the insured. 5. Not attempting in good faith to effectuate prompt, fair, and equitable settlements of claims in which liability has become reasonably clear. 6. Compelling insureds to institute litigation to recover amounts due under an insurance policy by offering substantially less than the amounts ultimately recovered in actions brought by the insureds when the insureds have made claims for amounts reasonably similar to the amounts ultimately recovered. 7. Attempting to settle a claim by an insured for less than the amount to which a reasonable person would have believed he or she was entitled by reference to written or printed advertising material accompanying or made part of an application. 8. Attempting to settle claims on the basis of an application which was altered without notice to, or knowledge of, or consent of the insured, his or her representative, agent, or broker. 9. Failing, after payment of a claim, to inform insureds or beneficiaries upon request by them of the coverage under which payment has been made. 10. Making known to insureds or claimants a practice of the insurer of appealing from arbitration awards in favor of insureds or claimants for that purpose of compelling them to accept settlements or compromises less than the amount awarded in arbitration. 11. Delaying the investigation or payment of claims by requiring an insured, claimant, or physician of either to submit a preliminary claim report and then requiring the subsequent submission of formal proof of loss forms, both of which submissions contain substantially the same information. 12. Failing to settle claims promptly where liability has become apparent under one portion of the insurance policy coverage in order to influence settlements under other portions of the insurance policy coverage. 13. Failing to provide promptly a reasonable explanation of the basis relied on in the insurance policy in relation to the facts or applicable law for the denial of a claim or for the offer of a compromise settlement. 14. Directly advising a claimant not to obtain the services of an attorney. 15. Misleading a claimant as to the applicable statute of limitations. 16. Delaying the payment or provision of hospital, medical, or surgical benefits for services provided with respect to acquired immune deficiency syndrome or AIDS-related complex for more than 60 days after the insurer has received a claim for those benefits, where the delay in claim payment is for the purpose of investigating whether the condition pre-existed the coverage. However, the 60-day period shall not include any time during which the insurer is awaiting a response for relevant medical information from a healthcare provider, or canceling or refusing to renew a policy in violation of Section 676.10. That's the entire Fair Claims Settlement Practices Statute issued in California and which is used by plaintiffs and plaintiffs' lawyers to allege a case of bad faith against an insurer. And those suits will usually track 790.03H's various violations in setting up a bad faith suit and alleging that they have been so badly treated as to violate the statute. California then instituted a set of regulations to enforce the provisions of the Fair Claims Settlement Practices Act, which regulations micromanage the claims handling. And the regulations state basically their purpose by saying that Section 790.03H of the California Insurance Code enumerates 16 claim settlement practices that, when either knowingly committed on a single occasion or performed with such frequency as to indicate a general business practice, are considered to be unfair claim settlement practices and are thus prohibited by this section of the California Insurance Code. The Insurance Commissioner of the State of California promulgated these regulations in order to accomplish the following. 1. To delineate certain minimum standards for the settlement of claims, which, when violated knowingly on a single occasion, or performed with such frequency as to indicate a general business practice, shall constitute an unfair claim settlement practice within the meaning of Insurance Code Section 790.03H. 2. To promote the good faith, prompt, efficient, and equitable settlement of claims on a cost-effective basis. 3. To discourage and monitor the presentation to insurers of false or fraudulent claims. And 4. To encourage the prompt and thorough investigation of suspected fraudulent claims and ensure the prompt and comprehensive reporting of suspected fraudulent claims as required by Code Section 1872.4 of the California Insurance Code. The regulations are not meant to provide the exclusive definition of all unfair claim settlement practices. Other methods, acts, or practices not specifically delineated in this set of regulations may also be unfair claim settlement practices and subject to California Insurance Code Section 790.03H and or California Insurance Code Section 790.06. These regulations are applicable to the handling or settlement of all claims dealing with Chapter 1 of the California Insurance Code, commencing with Section 790. This video was adapted from an appendix to my book Construction Defects and Insurance, Volume 5, which is available as both a Kindle book and as a paperback from Amazon.com, and is available from my website Zalma.com by clicking on the Insurance Claims Library, where you will learn about this 5th volume of the 8-volume work, plus my book on the Fair Claims Practices Regulations, which is also available from Amazon.com as a Kindle book and as a paperback, which will give you not only the details about the regulations as read to you, but also on how to deal with them and how to properly handle claims in accordance with the regulations. If you found this video to be useful or interesting, please forward it to your colleagues. It's free. And please also subscribe to my Rumble channel and my YouTube channel, and subscribe to my blog so that you can learn about future videos and blog postings. Thank you for your attention.